Okay, thanks, Chair. Mr. Lewis, this might be out of your area, and I'm happy, Senator Brandis, if you want to take this one on, because I'm trying to establish who the lead agency is, and it might be ASIO, for right across the public service, around the issue of very large-scale theft of encryption keys from a Dutch SIM card manufacturer, Gemalto. I took it up with ACMA earlier in the day. But is it the AGD or is it ASIO specifically? Who's actually got the lead on establishing whether these claims are true and what response should be forthcoming if so?
ASD or the AFP. Senator, depending on, I suppose, the nature of the inquiry that you are proposing there would depend on whether it was the Australian ASD in Defence, Australian Signals Directorate, or whether it was the AFP. That would depend on the sort of the what's the word I'm looking for? It would depend on how precise the specificity, I guess, of the
right.
accusations or the investigation.
So I guess I've just missed the AFP. We can catch ASD later in the program. Are you aware of the nature of the issue that I'm raising?
I am aware of these. Yes. No.
Okay. All right. I'll follow it up. If anybody else at the table, or maybe even in the room, has a more precise answer. I'm trying to establish who's the lead agency, like actually who's advising the government. Senator Brandis, have you got anything you want to add? Is that something that's come across your desk?
No.
No? Not interested?
No, you asked me a question, and the answer to your question is no.
Okay. Can I ask you a different question? Are you interested? Is there anything that you would like to put to us? Is this something that you're working on?
I have nothing to add.
Nothing to add.
In answer to my question, which is no.
No. Okay. Have you been briefed on the issue?
No.
No. Okay. All right. So, Mr. Lewis, this will probably be reasonably quick. I've got one specific question to raise, and then one that's a little bit more general. It's an issue of an asylum seeker, Syed Abdelatif, who was convicted in an Egyptian military court a couple of years ago. The conviction, it's been later confirmed, was obtained by torture. He's an Egyptian father of 6. He's now in indefinite detention in Australia on the basis, I understand, of the security advice that was received from Egyptian authorities. As I say, later confirmed to have been obtained by torture. ASIO obviously is the lead on the security assessments of people who come into our immigration detention system. Is there anything you're able to advise us of as to whether ASIO's reconsidered its security assessment of this individual based on evidence that's subsequently come to light?
Senator Ludlam, I understand the question. The answer is that for both security and privacy reasons that I am unable to comment on the status of any individual with regard to their security assessment.
And that's it?
That's it, Senator.
What's your process for re-evaluating? Let's not talk specifics then if you're unable to go into the particulars of his matters. What's ASIO's process? Would you need to act on request of the Attorney-General, for example, or could you initiate a review on your own motion?
In this particular case, and normally it comes from the Immigration Department, Senator.
Right.
And we then conduct the security assessment in accordance with the arrangements that we have in place both internally in the organisation and under the legislative under the ASIO Act.
All right, thank you. So it's not, again, if you're not willing to discuss his particulars, that's a shame, but I won't press you further on that. I'm presuming it's not unprecedented that reviews would be conducted if new information comes to light that you consider would be material.
It's the norm, Senator.
Okay.
It is the norm. If new information is provided that in some way materially alters judgments that might have been made, then we do, within ASIO, go back immediately and review that situation. Over and above that, I should also add, Senator, that there is a process of regular revisiting of assessments that have been made. So there is a rotating program of revisiting. We can come back earlier than that regular rotation if new information is made available to us
Okay.
or comes to our attention.
He was convicted in 1999, and court documents have been provided to Australian authorities, I think, during 2013. How long, again, not going to the specifics of his case, how long would these reviews that ASIO undertakes, given your workload, how long would they take?
Oh, that can vary significantly, Senator, depending on the complexity of the issue. I couldn't give you a precise answer. There is too much variety.
Yeah, I guess. Okay. And is there any way for his, I don't know whether he's currently retained lawyers or exactly what his circumstances are, but how does either he or those who might believe that he's being unlawfully detained, how should they interact with ASIO, I guess, on a confidential basis so as not to prejudice his privacy or security? How should they approach the kind of questions that I'm putting to you now to work out whether he's being unfairly or unlawfully detained?
Well, as I say, Senator, I won't go to the specifics of this case, but any legal representative, any person who is representing on a legal basis a person that's subject to a adverse security assessment can communicate, and they do, on a regular basis with ASIO, in writing, by telephone, number of ways, but we do have regular contact with legal representatives.
All right, great. I'm going to have to assume that that's occurred in this case. I don't know that for certain whether it has, but it would be remarkable if it hadn't. Can you just confirm for us that ASIO, like any other branch of the public service or the judiciary, would not consider evidence admissible if it had been obtained under torture?
Just rephrase that again, please.
For the purposes of the security assessments, I understand they must be extraordinarily difficult given the breadth of regimes and individuals that you're going to have to come in contact with, that if evidence, not for this specific case, but in general, if evidence is identified to have been obtained under torture, are you required to treat it as inadmissible as a court would, or is there no such requirement on ASIO?
I can't think of an incident where that has come up, but if you are asking me to speculate on it, I would say that we would be putting it aside. I wouldn't regard that as acceptable at all.
That's an excellent answer, but I'm certainly not asking you to speculate. I'm asking what ASIO's internal procedures are.
Well, I mean, I've said this publicly, Senator. I think you've probably heard me say this, that ASIO doesn't employ or act in any way that sanctions, acquiesces or encourages torture. I mean, I've made that public. Yeah, that's some months ago. That's black and white, and it's greatly appreciated. So I'm not trying to. I'm trying to establish, I guess, how that very clear commitment that you've made again here would apply to the security assessments that you do over people who are fleeing regimes where torture is frequently one of the reasons that they've departed in the first place. Egypt being an interesting example. How does that interact or interface with the security assessment process? Well, I just don't see how evidence that's been obtained under torture would then come into our hands in that particular scenario you just portrayed. I guess this is one case where it has, but I'm not sure that we can take this any further. As I said, I can't speak to this particular case, but I assure you that those comments that I made with regard to torture stand. Yeah, okay. I've absolutely no reason to doubt that. I'm just trying to establish how it might help this gentleman out of the cage that he's in at the moment. All right, we'll leave that one there. Finally, from me, your predecessor some months ago did give evidence to the Senate's Legal and Constitutional Affairs Committee conducting an inquiry into the interception and access regime that exists in Australia. You'd have given similar evidence, I guess, on your own behalf to the PJCIS in recent weeks. A question that I'd like to put to you now, because nobody disputes the value of metadata, either in the kind of work that you do, anti-corruption agencies, the federal police. But I think what is in quite serious dispute is the benefits of bulk collection as opposed to targeted and discriminate collection. I want to put to you, in December 2013,
President Obama's review group on intelligence and communications technologies tabled a report with a series of recommendations the United States government, President Obama, had commissioned, which goes specifically to that question, not the value of metadata, but the value of bulk and indiscriminate collection in solving important national security issues and cases. Members of that panel gave evidence to the Senate's Judiciary Committee in January of last year, and Michael Morrell, who's a former Deputy CIA Director, said the bulk collection of domestic phone data has not played a significant role in preventing any terrorist attacks to this point. Apart from that, I've been unable to find any evidence, either in a law enforcement context or a national security context here or overseas, that bulk metadata collection of ordinary civilians and all the devices that we carry around actually has made a measurable impact in jurisdictions where it's been implemented. And I'm wondering if you can provide us with any evidence, because nobody else has been able to thus far.
Well, I can't, and I'm not here to speak on behalf of the circumstances in the United States, but I can say that here in Australia, Senator, we do not and have not engaged in bulk collection of the type you're describing. I think David Irvin, my predecessor, has made it plain, and I certainly have in various both public and private hearings, that we do not engage in that sort of mass collection, if you like, and there are several reasons for that. I mean, the first one is clearly legislative. We are not in a position to do that. We are required under the Act to have reasonable belief that there's a need to be interested in a particular data set. So we are legislatively bound, we are regulatory bound, we're bound by the attorney's guidelines, we are bound, of course, by the very simple issue of resources. So the notion of doing some sort of broad vacuuming, which is what I assume you're alluding to in the United States, and I don't know what the CIA officer you mentioned, what he said.
Oh, that was a quote that was a quote
yeah,
I put to you just now. But
I
recognise you don't have a transcript in front of you.
I can't account, and I'm not, nor would I try to account for what he had to say. But I can account for what goes on in this country, and I can tell you that is not a practice that takes place.
Of course. We might be slightly at cross purposes, because I certainly wasn't proposing, and if that was occurring, and I don't believe that it is, it would probably be ASD as the lead agency doing it. But that's not.
Well, I'm just
really
saying it doesn't happen, Senator. So,
no.
Yeah.
I understand. The proposal that's before the Parliament at the moment is to outsource that bulk collection to the telecommunications industry. I understand that ASIO doesn't do it. You are invoking an obligation on telecommunications carriers at a cost of $400 million or thereabouts, not you, but the government, to do that bulk collection. And I'm seeking evidence from you as somebody who's very, very well versed in how these operations work, to provide us with any evidence that it's that bulk collection that's actually necessary rather than targeted preservation of data.
If I just go back to your first question, which was about bulk collection, and when you cited the case of the evidence given by the CIA officer by name of Morrell, that's a very different thing to what I understand you to be asking now, which is we are asking for data retention. I wouldn't characterise it as bulk collection. I think that's a misrepresentation, but I stand to be corrected technically. But the data we are asking to be retained for 2 years has been laid out. It's available and publicly of what we are asking to be retained. We have given evidence both in closed sessions of the PJSIS and in open sessions of examples of where the data that you are describing has been of utility when inquiries have begun. In our case, in counter-terrorist operations, and I go back to the Pendennis case and others that have been cited before. So there are examples sitting there where that data has been useful. I'm sure that Commissioner Colvin, in his particular lane, has spoken also of the utility from his point of view. But from my point of view, there are examples there which we have provided in the past.
The distinction I'm trying to draw, and I'm happy to not...
Your time's almost up.
Okay, I recognise that. Thank you, Chair.
You've got another minute or so.
Well, this will be my final question then. I don't want to get hung up on definitions of bulk collection. IINet estimates it'll be it'll require the construction of one new data centre in this country a month. So we can say bulk or we can call it something else. The question is not the utility of metadata to the kind of work that you do or that the AFP Commissioner does. It's whether the very large scale and indiscriminate collection of the whole population has been shown in any jurisdiction to improve or prevent terrorist actions, for example, which was what Mr. Morell was talking about. And I'm asking whether you have any evidence in an Australian context or whether you're aware of any in any other jurisdiction, not anecdotes, but evidence as to any purpose for a scheme such as this existing.
Well, again, I go back to your comment about bulk collection. I don't think that is an accurate characterisation. What we're talking about is data retention. The data set is very clear. And at the risk of repeating myself, in my particular area of responsibility, let's take the terrorism issue. We have quite concrete examples where the preserved data or the data that we have been able to access, the metadata we've been able to access, has directly enabled the investigation about that particular incident to proceed and allowed the investigation to proceed to a point through to prosecution and the jailing of a number of individuals who were involved in planning terrorist attacks in this country, in both Sydney and Melbourne.
Do you believe, and this is probably yes and no, so it can be fairly quick.
Sorry, while I'm not here to, again, describe events in other countries, but I would be astonished if there were any other people in similar positions to mine in countries that we would regard as being like-minded around these issues who would have a different view of that.
Okay. Just finally then, do you believe, given the importance and the crucial nature of that in that kind of material, that ASIO should be required to get a warrant in order to obtain it, as you do, for example, for regular intercepts?
Well, I mean, that is a matter, of course, for the government to decide, and there is deliberation going on around that now. My personal view, and again, I've made this plain in a public hearing to the PJSIS back on, I think it was the 19th of January, that I do not support a regime that would involve, or a process that would involve warrant for what I regard as the initial metadata request. At that point, to have a warrant system would be unwieldy for all sorts of practical reasons. But obviously systems aren't there for our convenience. The important thing is that the unwieldiness of it would be such that investigations would be hampered and slowed. And so our reaction time, our responsiveness, our agility as an organisation would be diminished to a point that would have a significant impact on the way we do business. I should add, Senator, and I think you know this well, that of course once that metadata has been used to the point of having what I would describe as a lead, then of course we are immediately into the business of seeking a warrant if we wish to examine any of the content that's involved in that metadata search.
Okay, thanks, Senator Ludlam.